So we've got about 10 to 15 minutes before we have to stop. So I will open the floor for questions directly. Yeah, Sasha.
So this is for Professor House. You had mentioned about creating a judicial system, essentially treating arbitrators as judges. Thank you. So why not instead just plunge, maybe increase the resources available for, let's say, the WTO, have increased TRIPS enforcement there, and just maybe merge the private party state dispute settlement process with the state-state dispute settlement process, which is already basically a company pressuring their state to file suit against another state?
Well, it's certainly in principle an option. It would require much more significant funding of the WTO dispute settlement system. I would be comfortable with using the WTO appellate body, but the panel system at the WTO has its own problems. So the panelists are amateurs, and so the WTO Secretariat has usually an inordinate influence on the rulings. So I don't think we could use the panel system. There might be some merit to expanding the appellate body and using it. On the other hand, as you may know, the appellate body is now under attack by the United States, and it's going through a very difficult time. But also, as I've emphasized, and I have a paper on this that's just been published today in the Yearbook of European Law on the idea of a multilateral investment court. It seems to me one of the fundamental unjust asymmetries with this system, and people try to defend it as rule of law, is that only investors can sue. There are investment disputes where, there are indigenous peoples, there are workers and others, communities who are negatively affected by the conduct of the investor, or sometimes the conduct of the state with the investor. They have no rights to sue. So my suggestion for a multilateral court is that in order to get standing before that court, investors would themselves have to agree to be sued before the multilateral tribunal by other groups who've been negatively affected by the conduct of the investor. It's ridiculous to say that multinational corporations get the rule of law, but not other people affected by what they've done. And we've had some references to labor and environmental provisions that have been put in some newer agreements, but you have to understand those provisions do not give labor groups or environmental groups any right to sue companies under investor-state arbitration. That's a prerogative solely reserved for investors. And again, when people talk about this as required by the rule of law or as representing international justice, it seems to me that a system where only one side can go to a tribunal and get justice is profoundly defective from the point of view of the rule of law.
Let's see, Sean?
Let me just ask kind of quickly for a comment on it seems like the point of the Eli Lilly decision was that they suggested at least that you could bring a claim for something like a drastic change or an egregious change, dramatic change in law that alters kind of expectations of intellectual property holder. Why don't you just comment on that? And do we see that same standard in other cases? Like, is that parallel?
Very briefly, so there's an outrageous decision that actually uses that standard to give an award to the investor. That's the Iser case, Iser v. Spain, where Spain set up this incentive system for renewable energy, and then they discovered that there were problems with the design of the system, that they were then faced with fiscal austerity. They did what any sensible government would do, which is they tweaked the incentives and reduced subsidization that it turned out to be unnecessary to incentivize the level of production of renewable energy required. And so Iser goes and says, no, we're entitled, as if we had a contract with the government, to exactly the same level of state aid as we had at the outset of the scheme. And the tribunal pulls out fair and equitable treatment. And how do they distinguish the fact that an earlier case, Sharon, had faced the same fair and equitable treatment argument, and the tribunal had rightly said, fair and equitable treatment is not a guarantee of future subsidies endlessly from a government. Well, they said this was a bigger change. So if there's a big change to regulation, then you get skewered by the investor under fair and equitable treatment. But of course, a big change may be a necessary change. The fact that a change in regulation is big or happens in one fell swoop rather than incrementally may be entirely rational from a public policy point of view. So that's an example of that standard being used against the ability of a state to introduce necessary and legitimate regulation.
And I would add too that, I mean, so the Eli Lilly case is about, it's a challenge to the common law process and sort of a court decision, but the case doesn't stand for the proposition that dramatic change is only impermissible when effectuated by courts exercising their common law duties. The case applies to dramatic changes by any instrument of government, and so legislatures cannot dramatically change the law. The executive branch cannot dramatically change the law. Courts cannot dramatically change the law. And so I think the interesting sort of thing to think about is, have we had dramatic changes in, for example, U.S. IP law? I'm not an IP expert, and so I'll look for you to email me examples that I can cite in the paper.
Just on that point, that's exactly why Rochelle and I, in the morning, cornered this paragraph as the gateway to further disputes, because it's clearly set there to say, find us something. And so that's a very useful example, Rob. And you know, we listed a number of these gateways, and Cynthia mentioned one, which at the end it says, this has been an extremely difficult and interesting exercise and not at all a frivolous claim. Bring on more. That's exactly what it says. So, you know, the gateways in it, in fact, there are hundreds of gateway paragraphs. We pinpointed a few. The fast and slow change. I mean, it's totally preposterous to suggest that you don't need fast change in IP law when that is what we hear all the time. I mean, okay, no one actually knows how to write the digital copyright fast change. But of course, as Rochelle pointed out in a slightly different way, Eli Lilly itself advocated for fast change of the non-obvious standard or whatever it was. Yeah, written description.
Not that many years before they bring this Lilly case.
Yes. So what I wanted to build on that and ask Rob is, you hinted at you were bringing this Unker trial case. What I wanted to ask you is if you thought, yeah, if you
the pleadings on the ITA law website.
Yeah, my question really is if you thought that in the ICSTD system or the Unker trial system, even though there are similarities in rules in different institutions, and of course there are other arbitral institutions. We focused a lot on the ICSID system today. If you think that the changes you indicated are more likely in one of those institutional systems than others.
Yeah, I think more likely in UNCITRAL, because ICSID is itself an entrenched bureaucracy where there's a clientist relationship between, the ICSID administration at the high levels. I'm not talking about the younger people who serve as counsel in the cases. I find them to be very good and impartial and so on. But at the higher levels at ICSID, there's a clientist relationship with the big law firms, the super arbitrators and so on. You could see it in the way that conferences are organized, who's invited to what panels. There's a whole, sociology, of networks that's going on here that some scholars in political science or political economy are mapping. And I could give you references to some of that work. UNCITRAL has the advantage, at least in terms of the arbitration rules, to be much more decentralized. And it works with institutions like the Permanent Court of Arbitration, which deals with many different kinds of international disputes, not just investment, and hence, unlike ICSID, is not subject in its, the higher levels of its administration to being captured by, a kind of a clique, that is dependent upon making a fortune from this one form of international dispute settlement. So those would be my observations. But the people at the working levels, I think, are generally very impartial and reasonable. But when you get up to more senior levels, it's the top arbitrators and senior partners, head of international litigation at X firm in New York or Y firm in DC or Brussels, that hobnob with, the top ICSID officials. It's a very symbiotic relationship.
Another solution could be that in your bid you default to the UNCTAD not to the ICSID. Is that a possibility?
Often there's a choice in the treaty between UNCTAD and ICSID, but I wouldn't regard UNCTAD as, by any means a panacea. I mean, but and ICSID does have the annulment process, and obviously in this particular case that I was referring to, we're placing some hope that that process will be a genuine corrective. And for various reasons, I think the annulment process is less subject to, let's say, political manipulations at high levels in ICSID than the tribunals of first instance. But it would require a longer explanation. I've already tried people's patience, and those of you who could stay really should go and listen to Una.